is a special edition from Boston, Lanka. The removal of the 43rd Chief Justice of Sri Lanka, Dr. Shirani Bandaranayake, was done about a year ago. She was impeached by Parliament and then removed from office by President Mahinda Rajapaksa. Dr. Bandaranayake was accused of a number of charges, including financial impropriety and interfering in legal cases. Dr. Bandaranayake denied all charges. Justice Bandaranayake was appointed to the Supreme Court in October 1996 by President Chandrika Kumaratunga. In 2011, President Mahinda Rajapaksa appointed Bandaranayake as Chief Justice.
ගුරු දෙමාපිය යුවලකට දාව කුරුණෑගලදී උපන් ශිරානි අංශුමාලා බණ්ඩාරනායක මූලික අධ්‍යාපනය ලබන්නේ ගිනිගත් හේන ප්‍රාථමික විද්‍යාලය, කෑගල්ල බාලිකා විද්‍යාලය, තෝලංගමුව ප්‍රාථමික විද්‍යාලය, තෝලංගමුව මධ්‍ය මහා විද්‍යාලය හා අනුරාධපුර මධ්‍ය මහා විද්‍යාලයෙනි. කොළඹ විශ්වවිද්‍යාලයට ඇතුළත්ව 1980 වසරේදී නීතිවේදී උපාධිය ලබා ගන්නා ඇය 1983 වසරේදී දර්ශනපති උපාධිය ලබා ගත්තාය. ශ්‍රේෂ්ඨාධිකරණයේ නීතිඥවරියක ලෙස එම වසරේම දිවුරුම් දුන් බණ්ඩාරනායක මහත්මිය 1986 දී ලන්ඩන් විශ්වවිද්‍යාලයෙන් ආචාර්ය උපාධිය ලබා ගත්තාය. ඒ විදේශ විශ්වවිද්‍යාලයකින් නීතිය පිළිබඳ ආචාර්ය උපාධිය ලබාගත් ප්‍රථම ශ්‍රී ලාංකීය කාන්තාව ලෙසයි. ශ්‍රී ලංකාවේ 43 වන අග්‍ර විනිශ්චයකාර තනතුරේ ඇය අද දිවුරුම් දුන්නේ මෙරට අධිකරණ ශාස්ත්‍රයේ ඉහළම තනතුරට පත් ප්‍රථම කාන්තාව ලෙසයි.
The day after the Supreme Court's determinations on the Divi Neguma bill were passed to the President, an impeachment motion against Chief Justice Bandaranayake was handed to Speaker Chamal Rajapaksa with signatures of 117 UPFA MPs. An 11-member parliamentary select committee consisting of 7 government MPs and 4 opposition MPs was appointed to hear the impeachment charges.
In the normal process we are used to, the judicial process, you find one party accusing, a different party judging, a third. So what you might find in a normal criminal case, the Attorney General or the police might make the accusations. There will be an impartial judge who tries the case, who listens to the evidence and comes to a conclusion. I must say I have my grave concerns when the accuser also judges. I have my grave concerns.
An 11-member parliamentary select committee consisting of 7 government MPs and 4 opposition MPs was appointed to hear the impeachment charges. Dr. Bandaranayake walked out of impeachment hearings when some government select committee members insulted her and had shown bias against her. The select committee members from the opposition withdrew from the committee next day. In an unprecedented manner, a thick volume of Parliamentary Select Committee report was presented to Parliament on 8th December 2012, the day after opposition members withdrew from the committee. The remaining Select Committee members who belonged to the government party found that 3 of 5 charges against Bandaranayake had been proven, and this was enough to remove her from office. The Supreme Court on January 1, 2013 ruled that the Parliamentary Select Committee had no power to investigate allegations against the Chief Justice, and the impeachment was therefore unconstitutional.
An independent judiciary is an essential feature for a functional democracy, where the courts are regarded as temples of justice. The judiciary has been throughout the centuries and is the formidable protector of the rights and individual liberty of every citizen in a democracy. As all of us are fully aware, the 3 branches of the government, that being the executive, the legislature and the judiciary, rest upon the basic and the firm foundation of the rule of law. It is therefore an unwritten law that if the rule of law is not observed, the 3 main organs of the government cannot function, and there would be irreparable damage to the basic concepts of equality and freedom. Therefore, for the existence of an independent judiciary, it is not only necessary but would be essential to ensure that the basic principles of rule of law should be observed at every level to all citizens on an equal basis.
Hearing an appeal from Dr. Bandaranayake, Court of Appeal quashed the Select Committee findings on 7th January 2013. The government ignored the Supreme Court and Court of Appeal rulings and went ahead with the impeachment. The impeachment motion against Bandaranayake was debated by Parliament on January 10th and 11th, 2013. The motion was passed by Parliament with 155 MPs voting for and 49 MPs voting against it. The 43rd Chief Justice Dr. Shirani Bandaranayake was removed from office on January 13, 2013 after President Mahinda Rajapaksa ratified the impeachment motion passed by the Parliament.
We can't be breaking the law and the standing orders. If we say Parliament is supreme, let's go through that. I am the one who got hit most for saying Parliament is supreme. But we should. That's why we are here. I think Parliament is supreme, but we must follow the law.
Opposition politicians, lawyers, judges and other civil society groups have criticized the impeachment as an attempt to control the independence of the judiciary and concentrate powers with President Rajapaksa.
I filed the petition in the courts on the grounds that there is a need for interpretation of the Constitution, because democracy must prevail for future good governance and growth of this country, because without rule of law and justice, no investor will come here and invest in this country. And if we want jobs for our youth and prosperity for our people, we need justice and rule of law. And in pursuit of that, only I am protesting today, and I have filed the petition in court.
They also claim the impeachment is in retaliation for the Supreme Court blocking the Divi Neguma bill.
Well, impeachment is politically motivated. The Chief Justice has given several judgments against the government in cases on facts, and I think the government is hell-bent on get rid of the Chief Justice.
President Rajapaksa tried to put the blame on the United National Party and opposition members.
පාර්ලිමේන්තුවේ කරන්නේ දෝෂාභියෝගයක් ගේ. ඒකේ තියෙනවා විශේෂ සලකලා විනිශ්චයකාරවරුන්ට අග්‍ර විනිශ්චයකාරයෝ විනිශ්චයකාරවරුන්ට කොහොමද දඬුවම් කරන්නේ කියලා. උන්ට තවන් උසාවියක් නැහැ. එතකොට ඒක කරන්න ව්‍යවස්ථාවේ තියෙන්නේ පාර්ලිමේන්තුව. අපි දාපු සභාපති, අපි දාපු අග්‍ර විනිශ්චයකාර, සභාපතිව NSB එකේ කොයිදීටි මෙයා දැන චෝදනාවක් ඇවිල්ලා මුදල් ගන්න දෙනුවක ෂෙයාර්ස් පික්කා කියලා නේ අඩුවට වැඩි මිලක තිබිච්ච එක මහා ලොකු කෑ ගහලා ගැව්වා පත්තරවල ගහනවා හැමදාම හෙඩ්ලයින්ස් මම ඉක්මනට කතා කරලා බීබීට කිව්වා මේ මිනිස්සුන්ට එන්න කියලා මේක ඉක්මනට ආපහු මේක සල්ලි ටික ආපහු දීලා මේක ආපහු ගන්න කියලා ෂෙයාර්ස් ටික කියලා යහන්තම් ඒක වහලා දාලා සේව් කරලා ඉතින් ඉවනේ කරන්නේ අපේ මිනිහට කොහෙද විපක්ෂය ගිහිල්ලා අල්ලස් කොමසාරිස් ගාව පැමිණිල්ලක් දැම්මා ඊට පස්සේ කිව්වා මෙයා විතරක් වර්ධිකාරය නෙවෙයි මේ ස්වාමියා කරපු වරදට බිරියටත් දඬුවම් කරන්න ඕනේ. එයා ඉන්නේ ඉහළ තනතුරක. දෝෂාභියෝගයක් ගේනවා කියලා මුලින්ම කිව්වෙත් එක්සත් ජාතික පක්ෂයේ මහලේකම්වරයා.
The traditional left parties who have been partners of the government became a laughing stock, especially veteran politicians like Vasudeva Nanayake. TNA MP attorney M.A. Sumathiran was very critical of MP Vasudeva Nanayake.
Yeah, I know. That is what you will do. That is what you will do. One of the three organs of government, you say is a democratic institution. You go and say that this is a democratic country. You go and say that there is an independent judiciary. And today, Honorable Minister Vasudeva Nanayake in this house is saying we have told the judiciary to go to hell. We won't allow you to do that. We won't allow you to do that. That is a sure way of sending this country down the slope, and that is what you are doing. We will not allow you to do that. This country is a country that is a democratic institution. This country there must be rule of law. If there is to be rule of law, there must be an independent judiciary. We can't allow you to send the judiciary to hell. Who are you? Who are you? I am a citizen of this country. I am entitled to say that this country must have every democratic institution. Who are you to say send the judiciary to hell? You are the conspirator against the country's interest. If you say send the judiciary to hell, you are the one who is conspirating against the country, against this government. That must be what you must be trying to do. Because you announced to the country that you will vote against this. You announced to this country that you will vote against this. 2 days ago, you got scared. You got scared that your ministry will be taken away from you.
Dr. Bandaranayaka's controversial impeachment has drawn much criticism and concern from outside of Sri Lanka. Condemning the removal of Chief Justice Dr. Shirani Bandaranayake, the independence of judges and lawyers of the International Commission of Jurists sent an open letter to the Speaker of Parliament Chamal Rajapaksa and the President Mahinda Rajapaksa, characterizing the action against the Chief Justice as unconstitutional and in contravention of international standards on judicial independence. The letter emphasized that an independent and impartial judiciary is essential for the protection of human rights, the rule of law, good governance, and democracy.
In order to uphold independence, a judge must be willing and able to make many sacrifices. A judge must be willing and able to sacrifice what others are capable of enjoying in order to uphold such independence.
The United Nations Special Rapporteur on the Independence of Judges and Lawyers, Gabriela Noll, issued a statement urging the Sri Lankan government to reconsider the impeachment and ensure that any hearing complies with the fundamental principles of due process and fair trial. United Nations High Commissioner for Human Rights, Nawai Pillay, expressed deep concern about the impeachment, which according to her had further eroded the rule of law in the country and could also set back efforts for accountability and reconciliation.
In 1867, Walter Baggot commented that the worst judge is a deaf judge. I believe it is apt to amend this sentiment in relation to this crucial judicial and socio-economic juncture of our country. The worst judge is not merely one who is deaf, but one who also succumbs to pressure. It is as much the responsibility of the judge to stand above it without any fear or favor as it is the responsibility of the legislature, the executive, and the society at large to ensure that they are capable of discharging their constitutional duties without undue adverse intimidation.
Issuing a statement, the Commonwealth Secretary General Kamalesh Sharma stated that the dismissal of the Chief Justice will be widely seen as running counter to the independence of the judiciary, which is a core Commonwealth value. According to the report of the International Bar Association's Human Rights Institute issued in March 2013, the removal of the 43rd Chief Justice, who had been on the Supreme Court for 14 years, by the country's Parliament and President was done in contravention of a clear ruling by Sri Lanka's Court of Appeal. The International Bar Association's Human Rights Institute concludes in its report that the ramifications of the removal of Chief Justice Bandaranayake go far beyond the disputes that brought actions against Dr. Bandaranayake. Human Rights Institute believes that the executive has been dismantling institutional limits on its power since the passage of the 18th Amendment to the Constitution, and any Chief Justice appointed directly by the President in present circumstances is liable to lack the capacity to stand up for the judiciary against the executive. According to many legal and political observers, Dr. Bandaranayake is an unlikely symbol of judicial independence. In May 2011, she became the first woman Chief Justice appointed by President Rajapaksa following the enactment of the divisive 18th Amendment to the Constitution, which abolished the short-lived Constitutional Council and granted the President increased appointment powers over the judiciary and the range of other previously independent state entities. At the time of her appointment, many human rights lawyers and other activists called her a Rajapaksa loyalist. The fallout with the regime began over the controversial Divi Neguma bill, which proposed the creation of a centralized development authority combining all provincial agencies under Economic Development Minister Basil Rajapaksa. The legislation would effectively transfer 80 billion rupees, $700 million in development funds to the minister's control without any provisions for oversight. The bill also included a secrecy clause that could block whistleblowers from reporting corruption. The Supreme Court, led by Bandaranayake, prevented passage of the bill on 2 separate occasions.
This is actually a question of, in a sense, a confrontation between judiciary on one hand, the executive and the parliament on the other. Definitely this should have been avoided by withdrawing the impeachment. That is what the appeal of the bar, that was the appeal of the Mahanayakas, that was the appeal of most of the political parties, etc. But the government is completely ignoring all these requests. They are going ahead with this impeachment quite unfairly and quite unconstitutionally.
While critics charged the impeachment proceedings to be unconstitutional, the government portrayed its actions as rescuing the Supreme Courts from Shirani Bandaranayake and affirming the authority of Parliament. State-owned newspapers accused the lawyers and activists who supported Dr. Bandaranayake as helping some Western countries to destabilize Sri Lanka and stepped up the smear campaign against those dissenters and against Bandaranayake herself. The leading party in the opposition, the United National Party, did not show much interest in fighting for Dr. Bandaranayake, and it left a group of human rights lawyers and some members of the civil society to fight for the integrity of the process and to safeguard the dignity of the Chief Justice.
මට කාටවත් ස්තුතිවත් කියන්න ලැබුණේ නෑ මට අවස්ථාවක් හම්බ වුණේ නෑ මම නිවේදනයක් නිකුත් කරනවා මම අවුරුදු 16ම වැඩ කරේ බොහොම ස්ථිරසාරව නීතියට අනුකූලව.
Many local and international scholars were shocked how quickly the proceedings against Dr. Bandaranayake were conducted. According to the Asian Human Rights Commission, the most astonishing, outrageous and mysterious aspect of the impeachment proceedings was how quickly and speedily the proceedings were done against the Chief Justice of Sri Lanka. The impeachment proceedings against Chief Justice Neville Samarakone in 1984 took 6 months before the government decided not to proceed. At its deliberations, then Parliament MPs Sarath Muttettuwegama, Anura Bandaranayake and Dinesh Gunawardena cautioned about using hurriedly passed rules to judge the highest judicial officer in the land. In that light, some legal scholars wonder how the members of the Parliament Select Committee could examine more than 14 charges against Dr. Bandaranayake, examining 16 witnesses, reading more than 1,000 documents of complicated financial statements, consider various legal opinions and then finally to draft a long report to be presented to the Parliament. All this was done in 2 days. Was the Chief Justice Shirani Bandaranayake guilty of a serious and proved misbehavior? Due to the manner the proceedings conducted against her, this will remain a question forever.
Our security is with you all. Look after us. Look after 3 of us. Please look after 3 of us.
It says that justice delayed is justice denied, but justice hurriedly rushed is justice destroyed.
Article 13(3) of our Constitution clearly states that any person charged with an offence shall be entitled to be heard at a fair trial by a competent court. In order to ensure that justice is meted out, the judges must be able to carry out their functions in the calmness, serenity and safety which are necessary for their independence.
In the final analysis, this is not about Dr. Shirani Bandaranayake. It is about the Sri Lankan people. If this can happen to a Lady Chief Justice, what is the fate of others?
අධිකරණයේ පිහිට අපේ සමීප මාවච්චවන්නේ